Good evening and welcome to the first Gladiator Olympics. My name is Justin Bernstein. I'm the Director of Trial Advocacy and a Professor of Law at the UCLA School of Law out here in California. I'm also the creator of the Gladiator competition by Stand Up Mock Trial. And the purpose of this event is to join forces and to create an opportunity that didn't exist before this. Specifically, Gladiator is the national one-on-one competition for high school students. We've had it since 2015, but we wanted to expand the opportunity to have students participate from across the country. And to do that, we joined forces with Mock On, who's hosted the Tournament of Champions the last 2 years. You see their creators on screen, Ria Lakaraju, Ben Ademski. You want to say hello?
Hello, everybody. Thank you so much for joining us.
Hi, everyone. Thanks so much for being here.
Ria and Bennett are all-American attorneys from the American Mock Trial Association, from their schools, Emory and Tufts. For those who don't know, that means they were part of the top 1/3 of 1% of the college competitors from across the country. They're both finalists at Trial by Combat, the law school version of Gladiator. They're incredible competitors, now graduates, and as you'll find, great hosts as well. They get the lion's share of the credit for hosting this event. And we're thrilled to be joined and supported by Will Warahay. Will, do you want to introduce yourself?
Sure. Good evening, everyone. My name is Will Warahay. I'm an attorney here in Atlanta, and I coach Georgia Tech's team here in Atlanta. So we're glad to have you. Thank you for joining us.
Will was the tournament director for Gladiator 2022 in Atlanta, our first time outside of California. He's also the former president of the American Mock Trial Association, meaning he was in charge during his term more than 70 competitions across the country. You couldn't ask for a better group, and I'm thrilled to be joined by them this evening. So our medal rounds begin with pretrial. Will's going to be emceeing that as our presiding judge, so to speak, and I'll turn it over to him.
Great. If we get our first competitor, Genevieve, turn on your camera. Genevieve, you just want to take a second to introduce yourself, give us your name and what school you're competing from?
Of course. Good evening. My name is Genevieve Ahuja, and I'm from Trinity Pacific Christian School.
Great. Welcome. And so you'll have 4 minutes. We'll be keeping time, and we'll put some indications in the chat for you. And with that, you can proceed when you're ready.
Yes, Your Honor. Good evening, Your Honor. My name is Genevieve Ahuja, appearing on behalf of the United States. Today, the defense has brought a motion to exclude Exhibit 3, the defendant's criminal record, from evidence, arguing that it contains inadmissible character evidence under Rule 404. We oppose their motion for 2 reasons. First, under Rule 609, any felonies are automatically admissible if, when being offered to show untruthfulness, the probative value of the evidence substantially outweighs its prejudicial effect. And second, under Rule 404b2, character evidence is admissible to prove intent. Now, first, let's take a look at the contents of Exhibit 3. It lists 3 instances in which the defendant was arrested. He was arrested for attempted murder, assault, and domestic violence regarding his ex-girlfriend. Now, because the second arrest resulted in a dismissal of charges and therefore amounts to nothing more than an unsupported accusation, we're seeking to offer a redacted form of this exhibit into evidence, consisting of only the first and third arrests. That being said, let's take a look at why this exhibit has probative value. Now, on July 4th of this year, Tracy Hancock attempted to enter a large political rally with an assault rifle. Officer Patty Lester stopped him at the checkpoint, searched him and his car, and then arrested him. Today, we're charging the defendant with attempted murder. The question in this case isn't what the defendant did. That's undisputed by both parties. He brought a gun to a political rally. The real question in this case is whether the defendant is lying about why he did it. Now, Mr. Hancock claims that he brought this weapon to the rally for benign reasons, and because of that, evidence that shows whether or not he can be trusted is extremely probative.
Counsel, let me interrupt you with a question. Doesn't that require that the defendant testify?
Yes, Your Honor.
So if the defendant does not testify, the defendant elects not to take the stand, do you concede then that these prior convictions are inadmissible?
Not necessarily, Your Honor. Under Rule 609, Any felonies are automatically admissible if, like I said before, they're offered for untruthfulness and the probative value substantially outweighs its prejudicial effect. I believe that the rule only requires the defendant to be, or excuse me, the witness to be the defendant. I don't believe it requires for them to testify.
They need to be a witness, right? I mean, 609 only applies to a testifying witness.
Yes, Your Honor, it applies to a witness who needs to be a defendant in that case. So yes, Your Honor, the defendant would need to testify.
Okay, so do you have any probative value in the event the defendant elects not to testify?
Yes, Your Honor, there is probative value, but I believe that it wouldn't fall under this rule.
Okay, so what's the rule that would permit it if the defendant doesn't testify?
Well, Your Honor, I believe that the defendant will be testifying in this case, as the defense counsel has stated.
You can proceed.
Yes, Your Honor. Now, Exhibit 3 contains what have been designated crimes of moral turpitude under Rule 609A1. Crimes that, while not directly relating to the truthfulness of the defendant, go to show that the defendant is so morally compromised that he would not have the proper moral intuition to tell the truth. Shooting a gun into a crowd and domestic violence, the two convictions in Exhibit 3, both show the defendant to be morally compromised that he cannot be trusted to be truthful. And because the defendant's truthfulness about his intent is the sole issue in this case, this evidence is highly probative. The question now becomes, is this evidence substantially more probative than it is prejudicial? Now, the defense will likely argue that there's risk of the jury interpreting this evidence as inadmissible character evidence, offered to show an action in conformity with character for violence. That's not an issue in this case because there are no acts in question, which brings me to my second reason for the admissibility of Exhibit 3. The question in this case isn't the defendant's acts, it's why he acted or his intent. Now, while Rule 404A1 prohibits the use of character evidence to show an action in conformity with a character trait, Rule 404B2 explicitly permits character evidence to be offered for intent. Now, the defendant's past character for violence wouldn't be interpreted as evidence of violence in this case. It would be interpreted as evidence of his intent to commit violence. And by the letter of Rule 404, that makes this evidence admissible in trial today. In conclusion, Your Honor, because Exhibit 3 contains crimes of moral turpitude that are substantially more probative than prejudicial and go to the defendant's intent, we respectfully request that Your Honor deny the defense's motion and allow this exhibit in trial today. Thank you.
Thank you very much. I will turn it over to Ria and Bennett just to give a few comments or feedback, and thank you for your presentation.
Yeah, thank you so much. That was really fantastic. I personally, and this is not meant to cast aspersions on the other three categories of this tournament, think that this is the hardest category, that what you have to do here, especially in the live rounds, respond to questioning from someone who knows this case back to front and knows the law, is really, really difficult. And the thing that I was most impressed by here was your tone and your composure. Right out of the gate, you sound exactly how you want to sound arguing a motion like this. And you got asked a difficult question, and like he kind of got you a little, like it was a good point, and you recovered, right, seamlessly, right? You kept, when he said you could proceed, you just kept going, and that's exactly what you want to do. I was really impressed by that, and I thought it was fantastic.
Thank you.
I echo everything that Bennett said. You were absolutely fantastic. I'll give you a couple places I think that you can improve. So the first place, I thought you did a really good job generally laying out your structure, but the one place where I thought you could maybe add a little bit more is you do a good job. You know, you talked about this benign intent, crimes of moral turpitude. I think that you're right in citing the facts that support that. What I want is more of the logic for why you believe that each of those applies here, rather than just, you know, giving us a summary of what the crime actually was. For example, with the crimes of moral turpitude, you talked about what the crime was that you believe indicated that circumstance. I want to hear the logic for why that shows the kind of disregard for someone's safety that would make that then apply. And then the second suggestion I have is, you know, Justin really asked you some tough questions on that one. I think I agree with Bennett. You recovered really well. I would say you set yourself up right out of the gate with laying out all these reasons for why you believe you had more than one. If you're in a circumstance like that where the 609 rule doesn't apply, go straight to, your 404 example. That's why you have multiple rules of evidence in the first place for why something like this should be admitted. You even really at the beginning talked about that with redacting a section. So I think when in doubt, go to your backup reason. That's, never a wrong answer. But overall, really excellent job.
Thank you.
Congrats. Thank you very much.
Nice job, Genevieve.
Good evening. Could you just introduce yourself real quick? Just give us your name and what school you're from.
Yeah, of course. Good evening again, Shandon Klimico from Montgomery Bell Academy. It's in Tennessee.
Great. Welcome. Congrats for becoming a finalist in this pretrial category. So as you know, you'll have 4 minutes and we'll be posing questions throughout that, but you can proceed when you're ready, and Ria will be putting time limitations in the chat for you.
Good evening, Your Honor. Again, Shandon Klimico on behalf of Mr. Hancock. May it please the court. The issue before the court is whether Exhibit 3, Mr. Hancock's record of past criminal history, should be admitted against him as evidence of his guilt on the pending charge. It should not be. This court should grant Mr. Hancock's motion in limine and exclude Exhibit 3 for 2 reasons. First, it's improper character evidence under Rule 404. And second, Exhibit 3 is substantially more prejudicial to Mr. Hancock than it is probative to the government's case under Rule 403. Because Exhibit 3 contains 3 separate entries from Mr. Hancock's past, I'll address each entry separately. But first, as a threshold issue, my client does not intend to testify at trial. The government's opposition to our motion argues that Rule 608 and 609 offer bases for admission. But because Mr. Hancock will not be a witness at trial, his credibility will not be at issue, and Rule 608 and 609 do not apply. Turning to Exhibit 3's first entry. In 2013, my client was convicted of illegal use of a firearm and reckless endangerment. The government intends to offer these past criminal convictions in an attempt to prove that Mr. Hancock is violent, and therefore more likely to have attempted a violent act on July 4th, 2022. Rule 4 bars this use. Evidence of a crime is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with that character. But that's exactly what the government intends to do. The probative value of entry number 1 is low, and it's substantially outweighed by the risk that the jury will hear my client has committed a crime with a gun in the past, and thus instantly conclude he must be guilty of attempting another gun-related crime in this case. Moving now to entry number 2. This is the simplest analysis of the 3, Your Honor. In 2016, Mr. Hancock was wrongfully charged with felony assault for a supposed bar fight. Those charges were dismissed. The government cannot weaponize a mere arrest that resulted in no conviction because it offers nothing probative. The only thing entry number 2 could do is prejudice the jury against Mr. Hancock. And finally, entry number 3. In 2020, my client was convicted of felony domestic violence. As with entry number 1, the government intends to use this conviction to prove that Mr. Hancock is violent, and therefore that he was more likely to attempt a violent act on July 4th. Here, however, there isn't even a cognizable permitted use of this evidence. It's simply textbook propensity evidence precluded by Rule 404. Your Honor, for all these reasons, Mr. Hancock respectfully requests that this court grant his motion and exclude Exhibit 3 in its entirety. Now, we predict, Your Honor, that the government will make an argument as to the exceptions under Rule 404B, that is knowledge, perhaps.
Counsel, let me interrupt you. Before you get to the 404B arguments, I want to turn to 609. You said sort of summarily at the beginning of your argument that your client wouldn't be testifying. The pretrial order said that decision hasn't been made yet. And as you know, counsel isn't determined whether your client will testify. Ultimately, that's your client's constitutional right. So if your client does elect to testify, do you concede that these convictions, number 1 and number 3, are admissible?
No, Your Honor. Under Rule 609, even if my client were to testify, the probative value of the entry number 1, which is the only possible probative value that could be offered for these 3 charges, is substantially outweighed by the prejudicial value. But Your Honor, that's not even the threshold that we need to meet. Rule 609 says that the probative value must outweigh the prejudicial value for the evidence to come in, but the prejudicial value here, Your Honor, outweighs. That's true for a few reasons. First, Your Honor, is that both parties have already stipulated that Mr. Hancock has the knowledge of how to use a firearm. He has the permit already. The AR-15 was in his car, and he does not deny knowledge of how to use a firearm. For the government to attempt to offer this entry number one, again, this charge of knowledge of a firearm would be prejudicial because there's no probative value offered beyond the point of having knowledge of how to use a firearm in the first place, which
So
neither party is contesting.
That sounds to the court like a 404B response. You're responding to 404B. My question is, that was under 609. If your client testifies, then your client's credibility is at issue. That's particularly the case in an intent case like this, where the facts aren't really in dispute, but your client's mental state was. At that point, isn't credibility so important that the government should be able to introduce felonies to show a lack of moral turpitude, to show moral turpitude and therefore a lack of credibility?
To the extent that this entry is probative, Your Honor, it's outweighed by the prejudicial value of the entry. Because this was a firearm-related crime, the jury would be inflamed to hear about this previous firearm-related crime, especially, Your Honor, because of the nature of this crime, which was a school shooting, when the defendant himself was a senior. For the jury to hear that type of evidence would be substantially prejudicial and outweigh any probative value provided by the charge.
Thank you. You can return to your argument.
Yes, Your Honor. To the 404B argument now, which is the last thing I have on the docket, any knowledge, again, that Tracy Hancock, the defendant, would have of firearms is stipulated to by both parties, and thus any knowledge that would be gained of Mr. Hancock's own intentions, preparation, plan, intent, etc., would be outweighed by the prejudicial value. And Your Honor, for these reasons, Mr. Hancock respectfully requests that the court grant his motion and exclude Exhibit 3 in its entirety. Thank you.
Thank you. Well done. Well done. So I'll turn it over to Rhea and Bennett just to give a little bit of feedback. We appreciate your performance. Great job.
That was fantastic. I said this after the last entry, but I really feel like this is the hardest category. To respond to those questions in the moment is really hard because you don't know what he's going to ask. And I want to commend you on how seamlessly you answered the question. If somebody popped into this Zoom while you were answering Justin's questions, they would not have known that you were not delivering your prepared argument. And obviously, right, like if you had all the time in the world and you knew exactly what his question was going to be in advance, you would have written out and you might have changed exactly what you said. But the fact that it sounded exactly like you had prepared it, I think is really, really hard to do and was really impressive.
Thank you.
Yes, could not agree more. That was excellent. I thought you did a really great job of pivoting to some really difficult questions. Just like last time, I'll give you some suggestions for places where I think you can improve. So I have 3. The first section, you actually got to this a little bit later when Justin started giving you some questions, but when you addressed the defendant, whether or not they would testify, you talked about whether or not their credibility was at issue. I wish you had clarified that at the beginning. You sort of got to it when Justin then questioned you on it later, but I think, moving that up and fronting it, because that's sort of the basis of your argument, would have been a little bit helpful. The second suggestion, of course, the second suggestion with your 404 argument, you use this phrase when you were discussing the propensity evidence that he committed crimes with guns in the past. I think you want to tweak that to talk about, committing violent crimes. You need some sort of character trait included in there to sort of meet that bar for the 404 argument. You were close, but I think just making that small tweak would have clarified a little bit more. And then the third thing is that you referenced a lot how, the crimes would prejudice the jury. You sort of left it at that, though, that it would prejudice them. I wanted to hear more about why you thought it would prejudice them, in what way the specific nature of this crime could be particularly inflammatory as opposed to just any crime, because that's why you're asking for this specific crime to be excluded. But other than that, I thought you did an excellent job.
Thank you so much.
Great. Thank you again. You're welcome to hang out and watch the rest of the performances, or we can watch the live stream, or you're free to go. Thank you.
Thank you so much.
Great job, Janet.
Welcome, Michael.
Hello,
Just go ahead and introduce yourself. Give us your name and what school you're from.
my name is Michael DeBoe, and I go to Henrico High School in Virginia.
Great, welcome. Congratulations on becoming a finalist. So we will start the clock here for 4 minutes in a second, and then you'll take it away with your argument. Like we talked about, we may interrupt with questions, and Ria will put the time cues in the chat for you, so you'll see how much time you have left.
Okay.
So with that, proceed when you're ready. Good luck.
May it please the court. We, as the defense, have made a motion to exclude Exhibit 3, a record of my client's previous crimes and charges, dating from his high school days to 2020. This record is inadmissible for 3 main reasons. First, it fails to meet the requirements of Rule 609. Second, it's unfairly prejudicial and therefore fails to meet the test of Rule 403. And third, the government intends to use this evidence as to show that my client has a propensity to violence under Rule 404(b)(1). Now, I'd like to examine each charge in this record one by one, starting with Charge 2. Charge 2 is a felony assault charge taken due to a bar fight that my client had gotten himself into. The reason why this is inadmissible is simply because the case was dismissed. Under Rule 609, it requires that my client had been convicted for it, and he wasn't convicted. Even further, we have to look towards its prejudicial value over its probative value, and whether or not the government intends to use this to show propensity towards violence. There's very little probative value that the government can gain from this, considering the circumstances of this charge and the case at hand today are completely different. A bar fight is completely separate than my client being found with a gun in his trunk and being arrested for attempted murder. Now, next, I'd like to talk about Charge 3. Charge 3 is a felony domestic violence charge, as well as a felony stalking charge. The reason why this is inadmissible is because of one main difference: an intimate partner. The circumstances are completely different simply because the circumstance of my client having an intimate partner in relation to Charge 3. It was his ex-girlfriend. My client has no connection to Ms. Carla Gibo in today's case. And even further, the circumstances of felony stalking and domestic violence are completely different than the circumstances of, again, him being found with a gun in his trunk. And now we have to also acknowledge the jury member's perspective on a charge like this. We have to look to the fact that the jury members may be biased against my client when learning of this felony stalking and felony domestic violence charge, and therefore any probative value would be far outweighed by that prejudicial value. It's going to cause the members of the jury to look upon my client and presuppose that he's guilty simply because of a charge like this, because of its connotation in society as a domestic violence charge. And finally, Charge 1. Charge 1 is a felony illegal use of a firearm, a charge, as well as a reckless endangerment charge. And the main difference between this case and that is the fact that there's no idiosyncrasy between these cases. The circumstances are completely different. Considering the fact that this was an illegal firearm charge, as well as a reckless endangerment charge, and the one at hand today is with a weapon that was registered to my client, as well as simply him being found with a gun in his trunk, those circumstances are completely different. And therefore, all this charge is going to do is bias the members of the jury against my client. And as a person under criminal prosecution, my client has rights, and he has the right to be presumed innocent. And a charge like this and a charge like all the others could cause the members of the jury to assume and presuppose that he is in fact not innocent. And that in itself is unjust. Now, because of these reasons, we ask that you exclude.
I'm going to cut you off right there. I actually have one question. Earlier you referenced the circumstances for the domestic violence charge being different because of the nature of the people involved. Can you speak to the violence element of that? There were violent acts committed in both circumstances, and you're saying that there's an issue here about whether or not the defendant had a violent character. So why is that not similar between the two circumstances? Why is that a reason that it shouldn't be admitted?
Well, simply because propensity is inadmissible. And just because he may have a history of violent crimes doesn't mean that that can just be used against him. So to acknowledge, to figure out whether or not we can use this propensity-based evidence, we have to look to the exceptions. And a charge like this, like the charge of domestic violence, it doesn't fall into any of the exceptions under Rule 404(b)(2), therefore making it inadmissible propensity-based evidence. Now we ask that you exclude this record because it fails to meet the requirements of Rule 609, because it fails the test of Rule 403 because it is far more prejudicial than probative, and because we believe that the government intends to use this evidence in order to prove that my client has a propensity to violence. Thank you.
Mr. DeVoe, I have a question for you. You argued that the dissimilarity between the charged crime and your client's most recent criminal conviction, a felony, make it prejudicial and improper. But if they were really similar, wouldn't you be arguing to this court, look how similar they are? The jury's going to think he did it before he did it again. Isn't the dissimilarity between them actually make it more likely the jury's going to be able to distinguish the two and less likely your client's going to be prejudiced?
Well, the dissimilarity essentially makes it so the members of the jury are only acknowledging the violent acts involved in the crime. What I mean by that is essentially there's no repeated instance that the government can use to prove this propensity-based evidence to prove that my client would have committed this crime, because they are dissimilar. Just because my client may have been involved in a domestic violence charge, doesn't mean that he's going to attempt murder upon a politician. And because of those differences, it's very easy to acknowledge the fact that there is no probative value here. And therefore, only the circumstances of the cases and charges would cause for the members of the jury to be biased, like that domestic violence charge and the felony stalking charge.
Thank you.
Thank you, Your Honor.
Great. Yes, well done. Thank you, Michael. So we will turn it over to Ria and Bennett just to give a few comments and feedback. Ria or Bennett, take it away.
Great job, Michael. That was fantastic. This is a really hard category, and I really appreciated the way that you made your arguments. I think that in a lot of these submissions that we saw, there's been a lot of like, okay, this will prejudice the jury, propensity evidence. And I know you talked about that, but the way you talked about each one of those rules is you sort of anticipated the argument that the other side would make and then tried to knock it down yourself. And I appreciated that. I thought that the argument about the dissimilarity was creative. I'm not sure that it doesn't buy it, but I thought it was really, really clever and I appreciated it. And I thought that your response to Justin's question about it was very good.
Thank you.
Yeah, great job. Congratulations on making it this far. I really enjoyed your argument. My one piece of feedback was I appreciated that you went for the dissimilarity angle. I sort of got where you were going with it when you respond. I understood that you were trying to make the point that it makes it less probative because the circumstances are so different. But then on the other hand, you were also sort of arguing that that they're using it for propensity evidence because there's this clear train of violence throughout each one. So you're on the one hand, you're saying they're dissimilar. On the other hand, you're also saying that they have the similar underlying element of violence, so they can't use it because it's being used then for propensity purposes. I think it was you lost me a little bit when you started arguing both. I think you did a great job in handling the questions from Justin. And I don't think mine was phrased super clearly, but you did a good job responding to that as well. But I think it would have made it a little bit clearer. I think I would have found the violence argument, I think, a little bit more persuasive, that they're using it clearly for propensity purposes because they're all violent crimes, and then exclude it for that reason. But I thought that both arguments we made sense. Just maybe pick only one.
Thank you.
Great. Well done again, Michael. Thank you. You are welcome to hang out and watch the rest of the performances on the Zoom or on the live stream, whichever you prefer, but you are free to go for this evening. Congrats.
Okay, thank you.
Great. Welcome, Jacob. You turn on your camera for us. Great. If you just take a second just to say your name and what school you're here from.
Jacob Molina from Dos Pueblos in California.
Great. Welcome. Congratulations on making it to be a finalist in this pretrial category. And so we'll, the rules are 4 minutes. We ask any questions, the time will stop for that. And we will put time notations in the chat for you so you can see where you're at. Okay. And take it away whenever you're ready.
The defense moves to exclude Exhibit 3 on grounds that its admission would violate Rules 401, 403, and 404 of the Federal Rules of Evidence, and it furthermore is not admissible for impeachment under Rule 609. Exhibit 3 contains a list of Mr. Hancock's prior crimes and includes reference to starting a bar fight, a domestic violence conviction, and a conviction for attempted murder, saying that Mr. Hancock fired a gun in a school cafeteria. First, this evidence is inadmissible under Rule 404. 404 prevents the introduction of character evidence used to show that the defendant has a propensity to act in a certain way or acted in conformity with that character trait. This exhibit is being used to show Mr. Hancock's propensity to misuse guns, disregard the well-being of others, and act violently. And without these forbidden propensity inferences, this evidence is irrelevant under Rule 401. Whether Mr. Hancock committed a crime in the past isn't an element of today's case, nor does it make any element or fact of consequence more likely. Now, the government will likely try to introduce this evidence under Rule 404b2, which allows for the introduction of crimes, wrongs, or other acts in very limited circumstances. Under 404b2, they can be used to show things such as motive, intent, knowledge, plan, among others. However, it's not enough for the government to assert the evidence's relevance to a 404b2 permitted purpose. They must also establish a propensity-free chain of reason. Any relevance to something like intent or motive is reliant on the propensity inference that Mr. Hancock's behavior is likely similar to what occurred in the past. The government would be doing no more than smearing Mr. Hancock's reputation in front of the jury. And for that reason, this exhibit is also inadmissible under Rule 403, which allows the court to exclude relevant evidence if its probative value is substantially outweighed by its danger of unfair prejudice. Prior crimes are intrinsically prejudicial, and particularly when the charge resembles the one we see in today's case.
Mr. Molina, let me interrupt you with a question. I take your point that the prior crimes, if used to show likelihood of misbehavior with the firearm, might be problematic and inadmissible under 404. What about the idea that the most recent conviction involving domestic violence might be used to show that the defendant was unhinged, that he had problems in his personal life that might provide a motive and an explanation for why he would be willing to commit an act of violence against a general population or a political candidate? We've seen countless examples in the news over the last all too many years where somebody commits an act of public violence after personal misfortune. So why couldn't the government use this as evidence of motive, or at least the seed that led to the crime?
Your Honor, using past acts to show that they increase the likelihood of future acts is what the 404 rule against propensity prohibits. There is not a similar enough connection between domestic violence and what occurred in today's case to establish a clear pattern. All that would be doing is showing that Mr. Hancock is, say, angry, violent, or unhinged, and this is exactly what Rule 404 prohibits. It would be being used to show that Mr. Hancock is generally a violent person, and because of what he did in the past, he is more likely to do something in today's case. There is no evidence that there is a clear link between what occurred there and in today's case to establish a motive.
Thank you.
This evidence does also not go to the identity of the perpetrator as modus operandi, as there are not sufficient idiosyncratic similarities to establish an inference of pattern. Misusing a gun or acting violently in the past does not rule out other suspects or implicate Mr. Hancock.
Mr. Molina, can you jump to your impeachment argument? I'm curious to know why this doesn't apply under 609.
Yes, Your Honor. Even if Mr. Hancock chooses to testify, this evidence is still inadmissible under Rule 609. Under 609A1, in order for this evidence to be introduced, it not only has to meet the 403 standard of the probative value not being substantially outweighed by the prejudicial effect, but it has to be more probative than prejudicial. These crimes involve no particular act of dishonesty. They don't include any element of fraud or theft. And therefore, the prejudicial effect of these substantially outweighs any probative value to Mr. Hancock's credibility. Furthermore, arrest number 2 is not even a conviction, and thus is not admissible under 609, nor is it probative in any way, as it amounts to nothing more than an accusation. And for these reasons, even if Mr. Hancock chooses to testify, this is still inadmissible under 609, both due to the modified 403 analysis and because they are not sufficiently probative to his credibility. And this is related to the identity.
Let me follow up on that last point. You're sort of saying, I think, that unless it's a crime that involves dishonesty, then 609 doesn't apply. But that's not what 609 says. It says that in addition to crimes of dishonesty, crimes of moral turpitude, defined as felonies punishable by more than a year in prison, can bear on a witness's credibility. Here we have a criminal defendant whose credibility is paramount in this case, and we have 2 felony convictions in the last 10 years. Shouldn't the jury hear that when evaluating whether or not the defendant is truthful?
Your Honor, 609 does allow for the admission of crimes involving moral turpitude. However, what 609A1A is designed to prohibit is those which do not offer sufficient probative value as to the defendant's credibility, even though they still hold their prejudicial effect. It is true that this may be in some way probative to credibility. However, a crime of dishonesty is what would give it added probative value, and maybe one that overcomes the prejudicial effect from hearing about an attempted murder conviction and convictions of domestic violence. These still hold the prejudicial effect that it would elicit an emotional reaction from a jury after learning about someone's violent past. And whatever relevance there is to credibility because it's a crime involving moral turpitude does not outweigh the prejudicial effect and the judgments about Mr. Hancock's character that any juror is likely to make after learning that they fired a gun in a school cafeteria.
Thank you.
Your Honor, even if Mr. Hancock chooses to testify, he may open the door to evidence concerning his credibility, but he does not open the door to inadmissible propensity evidence, which seeks to do no more than prejudice the jury. And this is not relevant to the 404B2 purpose of identity under modus operandi, as there are not sufficient idiosyncratic similarities to implicate Mr. Hancock. These prior crimes include no reference of him driving somewhere with a gun, of him trying to assassinate a politician. They include nothing more than firing a gun and acting violently. All this is being used to show propensity to act in a certain way, that is, act violently and misuse guns. Nothing about this rules out other suspects or is specific to Mr. Hancock's way of committing crimes that connects to what occurred in today's case. And for these reasons, Exhibit 3 is inadmissible, as it is inadmissible propensity evidence and holds no relevance outside of that. It is also extremely prejudicial, and its admission would violate Rules 403 and 609. The defense respectfully requests that the court grant the motion to exclude Exhibit 3 for all purposes.
Well done. Thank you, Jacob. We'll turn it over to Rhea and Bennett for a little bit of feedback.
Really great job, Jacob. I was particularly impressed with the way you dealt with the questions. I thought the answer on 609 was really, really good. And I really liked your 404B2 answer. I thought Justin usually asks hard questions, and this was one of the first times I felt like you dealt with the question. Like, I was not worried about it after your answer. There's no evidence to establish any kind of link to make that a motive. I thought your answer was really strong.
Thank you.
Excellent job. I totally agree. I thought you handled the questions really, really well. That's actually my biggest point of feedback for you. I think it's important generally in this activity to know when you got it. I think you could have just ended really closely after that second question. You had a great answer. This is sort of a general theme I felt throughout your argument, start to finish. You clearly know your stuff. You explained the law really well. I think you over-explained a little bit in places where it wasn't necessary. And I think knowing when you've hit it is, and just cutting yourself off there is a really important skill. So I think in general, just try to like keep the logic. Once you've hit the point, just move on instead of, sort of hitting the nail on the head multiple times more than you need to. But you had us at that second question. I think you could have just ended it there. But great job overall. Really nice. Really nice.
Great. Thank you, Jacob. You're welcome to stay on and watch the rest of the competitors, and or we'll see you back in a little bit for the next round of competition.
All right, thanks.
Matthew,
Hello, can you hear me?
we can. Go ahead and just introduce yourself and tell us what school you're here representing.
Of course. My name is Matthew Poliu, and I'm here on behalf of Apple Valley.
Great. Welcome. Congrats on being a finalist in the pretrial category. So like you got 4 minutes. We will stop the time when you're asked any questions. Otherwise, the floor is yours. You can proceed when ready.
All right, thank you. Well, good morning or good afternoon or evening, depending on where you are. Today, we, the defense, respectfully oppose the government's motion to pre-admit documents of a prior crime. The prior crime evidence is irrelevant, highly prejudicial, and an improper use of character evidence. The government seeks to smear Mr. Hancock's character by presenting totally irrelevant facts. The only way they could be relevant is to lure the jury into convicting Hancock because of crimes committed in the past. But courts have widely held that prior crime evidence is unfairly prejudicial and threatens to convict a defendant on an improper basis. Rules 401, 403, and 404 independently preclude this evidence as a matter of law. The court should deny the government's motion. Let's start with Rule 401. Now, none of the government's evidence that they plan to pre-admit is relevant to the underlying offense. The government seeks to admit evidence of domestic violence, a school shooting, and a dismissed assault charge. These crimes have nothing to do with the facts and the circumstances surrounding the alleged attempted murder in the instant case. The next reason why the evidence should be excluded is Rule 403. Rule 403 has special force this prior crime evidence. The jury here would be invited to convict Hancock because of an emotional and prejudiced reaction to evidence of a prior crime, rather than based on the facts of the instant case. The risks that a jury will convict for crimes other than those charged or will convict because a bad person deserves punishment creates a prejudicial effect that outweighs ordinary relevance. Finally, the government's plan to present prior crime evidence runs afoul of Rule 404, which expressly prohibits what the government plans to do here. Present evidence of a crime, wrong, or other act to smear Hancock, whether as a school shooter or a wife beater or just a bad person, to then persuade the jury that Hancock therefore must have committed the underlying crime here. At this point, I'd like to ask if you have any questions regarding my arguments for Rules 401 and 403.
You can proceed at this point. Thank you, counsel.
Yes, thank you, Your Honor. Now, the government cited Rule 609 as a reason why the court should admit the evidence. First of all, 609 specifically applies to convictions. Many of the things listed on Exhibit 3 wouldn't qualify because they're records of arrests rather than convictions. However, even for the prior convictions listed under Exhibit 3, they'd still be unadmissible under Rules 609B and 609D. I'd like to remind the court that these convictions are years old. One charge almost dates back 10 years, and the defendant was less than a month above 18 at the time of conviction.
Counsel, let me interrupt you with a question. Doesn't the fact that they're within the last 10 years sort of presumptively mean that they are not time barred? I mean, if it's beyond 10 years, you'd be telling us that they're automatically inadmissible. So the fact that it's within the last 10 years, isn't that really an argument for the government, not for the defense?
Well, Your Honor, I think it's an important consideration. I would agree that under 609B and 609D, this evidence isn't automatically excluded, but I do think it's a relevant factor. These laws make it very clear that old evidence or juvenile evidence isn't admissible. So evidence that borders on the cusp of that should certainly be factored into the analysis. Does that make sense?
It does, but then what about the fact that the most recent conviction for your client was approximately 2 years before this incident and less than 3 years before this trial?
Well, Your Honor, I think specifically that third charge would really go towards the 609 analysis, or sorry, excuse me, the 403 analysis. That was a domestic violence case, and it really doesn't have that much to do with the instant case. I believe if there would be one case that is most probative to the current case, it would be the school shooting. I believe the domestic assault charge is completely irrelevant and substantially more prejudicial. That's why I'm focusing more on the school shooting.
Thank you. You can proceed.
Of course, thank you. I'd like to remind the court, once again, that these charges date back a long time. Given 609's preclusions of crimes greater than 10 years and juvenile convictions, the court should err on the side of caution and exclude the prior conviction evidence. And again, even if 609B and 609D don't explicitly prevent the admission of this evidence, Rule 609A does. 609A explicitly states that prior conviction evidence must be used to attack a witness's character for truthfulness. However, prior crime evidence in this case has nothing to do with a character for truthfulness. The prior convictions are reckless endangerment, domestic violence, and illegally wielding a firearm. Those charges have nothing to do with a truthful character. The government has also argued that pertinent traits of the defendant may be admitted, but the court must remember that's only when the defense opens the door. In today's case, the defense has no intent to paint the defendant as a truthful, law-abiding citizen. Our defense is one of facts, not character. Therefore, the door for rebuttal testimony is closed. Finally, the defendant intends to testify in these proceedings. So the government will have ample opportunity to use facts of the instant case to attempt to convict the defendant without the risk of prior crime evidence. The government is free to cross-examine the defendant on these relevant points without bringing in evidence that could potentially run afoul of Rule 401, 403, and 609. For these reasons, the court should exclude the government's prior crime evidence as a matter of law. Thank you.
Thank you, Matthew. Well done. We'll turn it over to Rhea and Bennett just to give a little bit of feedback to you.
Great job, Matthew. This category is really, really hard. Dealing with the questions is really hard. I thought you did an excellent job dealing with the questions. I liked how you sort of paused to ask if there were any questions, just so, no one would head you off while you were going. And I liked how you kept going when you got a question that, you can't be prepared for everything he's going to ask you, and you answered it and you kept going with your argument. And I thought that was really good.
Agreed. Really excellent job. I have two places where I think you could maybe tighten up your arguments a little bit to hopefully improve for the future. The first place, I think I'm now realizing that this is something that I noticed in other submissions as well. But I think you can clarify when you're talking about all these instances being dissimilar, it might help you to clarify, make the distinction that the reason that's important is because the government can't use it to prove knowledge under 404b2 because they're dissimilar. So there's no connection there. I thought that little link was missing. I think it's not enough to just say that they're different. I think you have to connect it back to how that relates back to the government's argument. The second place where I think you can clarify a little bit is your section on the age of the evidence. You talked about juvenile evidence. You lost me a little bit there. I think you can tighten up why legally the age of the evidence matters, how long, the time frame matters. I know that we don't have like case law and stuff in this, but I think strengthening that section for why, more recent crimes would be more probative would help you solidify that argument a little bit more. But really, really excellent job.
Yeah, truly. Thank you, Matthew. Congratulations on making it to this point. Thank you for your performance. You are welcome to hang out and watch the last performance here in this round if you want. Otherwise, you're free to go and can watch on the live stream too. So thank you.
All right, thank you.
Great. Cy Turner, you want to go ahead and introduce yourself? Tell us which school you're from, please.
Hi, Cy Turner from Montgomery Bell Academy.
Great. Congratulations on becoming a finalist here in the pretrial category. As you know, we'll give you 4 minutes. The time will stop for any questions that we ask you, and you can proceed when you're ready. Good luck.
Thank you. Good morning, Your Honor. Cy Turner on behalf of the United States of America. May it please the court. The issue before this court is whether Exhibit 3, the defendant's record of criminal history, constitutes improper character evidence under Federal Rule of Evidence 404. It does not. This court should deny the defendant's motion in limine and admit Exhibit 3 for two reasons. First, if the defendant chooses to testify, his felony convictions are admissible under Rule 609A1B to attack his character for truthfulness. And second, regardless of whether he chooses to testify, the defendant's gun-related convictions are admissible to prove his knowledge of firearms as a permitted use under Rule 404B2. I'll address each scenario separately, beginning with the defendant choosing to testify. When any witness takes the stand, he or she places their credibility for truthfulness at issue. Jurors must be able to determine the proper weight to give to a witness's testimony. The defendant has objected that Rule 404 bars his past criminal convictions as improper character evidence. But Rule 404A3 creates an exception via Rule 609. And Rule 609A1B states that when a criminal defendant chooses to testify, he may be impeached by any felony conviction as long as the probative value outweighs the prejudicial effect. And as an aside, this is not a Rule 403 type analysis. The probative value of the conviction need not substantially outweigh the prejudicial value. A mere tipping of the scales is sufficient under Rule 609.
Mr. Turner, let me interrupt you. The court takes well your point that it's not a 403 analysis, but you still need to show the probative value outweighs any prejudicial effect. What can be the probative value of gun-related convictions to somebody's credibility and truthfulness? I mean, none of these prior crimes, as far as I can tell from the document, Exhibit 3, none of them appear to relate to dishonesty. Am I missing something?
Yes, Your Honor. Rule 609 creates two exceptions, one for crimes of dishonesty and two for felony convictions. Here, entries 1 and 3 from the defendant's criminal history are felony convictions for a use of a firearm, reckless endangerment, and domestic violence. The rationale behind 609 is that if the defendant was willing to flout legal institutions in such a severe manner as to risk going to prison for over a year, that they might be willing to flout the law against perjury, and thus it goes to their credibility for truthfulness. These crimes were all punishable by more than 1 year in prison, and as such, the jury gets to hear about them. If the defendant was willing to flout those laws, as he was in the past and had pled guilty to, then the jury needs to know that he might be more willing to flout the law against perjury. Now,
okay, but on the other side of that scale, when we're considering the potential prejudice, doesn't the similarity between those prior convictions make it likely that even if you as the government intend to only use this for the defendant's credibility, that the jury's going to take it for the defendant's propensity? One of those crimes involves a firearm, the other violence, and the stigma of domestic violence is so heavy that how could the defendant possibly get a fair trial if that evidence is presented, even if it has credibility value?
Your Honor, I would point you to the bar for admissibility. As I said before, the bar is that the probative value merely must outweigh the prejudicial value any amount. Attacking the witness's credibility for truthfulness to the extent that they were willing to flout legal institutions and flout laws with crimes punishable by more than 1 year in prison, it goes to the witness's credibility and whether or not the witness would be willing to risk potential prison time for flouting the law against perjury. But now, turning to the second scenario, if the defendant asserts his Fifth Amendment right against self-incrimination and chooses not to testify, in this scenario, Rule 609 wouldn't come into play at all. But entry 1 from the defendant's criminal history is nevertheless admissible under Rule 404B2. Although the government cannot use the defendant's past convictions to prove propensity, certain permitted uses do exist. Under Rule 404B2, evidence of a past crime is permitted if the purpose of that evidence is to prove the defendant's knowledge. Here, the defendant was convicted of felony use of a firearm. Absent this conviction, there is no evidence on the record that he has knowledge of how to use a firearm, which is important given the government's theory of the pending charge, which is that the defendant was en route to kill Korea Gerbo with the intent of was en route with a gun with the intent of killing her. Additionally, this evidence does not create a risk of unfair prejudice under Rule 403 because the probative value is high and certainly not outweighed by the risk of prejudice. For these reasons, the United States of America respectfully requests this court admit entries number 1 and 3 from Exhibit 3. Thank you.
Nice
Great.
job.
Thank you. Nice job. I'll turn it over to Rhea and Bennett for a little bit of feedback.
Great job, Sai. That was fantastic. I really like the way you answered Justin's questions. I feel like that's sort of been my comment for everyone, but answering the questions is really, really hard. And I really like the way you answered his first question. He asked you about the dishonesty stuff. And, you know, it could have just been that you were saying, yes, Your Honor, to respond to his question, but he said, am I missing something? And you said, yes, Your Honor, and then proceeded to tell him what he was missing. And I enjoyed that because you were right.
Thanks.
Yeah, I thought you did a really excellent job. Those were some tough questions. I think that my only suggestion for improvement here is tightening up your argument with the connection to truthfulness and flouting the law. You referenced that earlier, and then again in the later question. I think making that connection a little bit clearer could help you. And then the only other thing I think is I liked that you kept it very simple. You didn't make too many arguments, which I think was good. But I think you can roadmap your points just a little bit clearer, because then you ended up making a lot of sort of sub arguments within. That said, I thought you did an excellent job handling the questions. Really nice.
That makes sense. Thank you so much.
Yeah, thank you very much. Congratulations on making it to the finals. Thank you to all of our finalists in the pretrial argument category. Congratulations, and we'll be announcing the winners for this category on Wednesday evening. So good luck to everybody. And with that, that brings us to the conclusion of the pretrial argument category. So we will go ahead and I guess take a break for a little bit. We'll be back in about 20 minutes, 20 or 30 minutes, I suppose, with our opening statement category, unless Rhea is going to tell me I got the timing wrong there.
No, you're right. It'll be about 30 minutes.
Okay, great. Great. If we can, once we get Justin back on screen, then we'll go ahead and get started with the opening statement portion.
Perfect. Good to see you all again.
Good to see you again. To everyone watching, welcome back. We're going to go ahead and get started with the second medal round of the night, our opening statements. I will say this was one of our most competitive categories. We did have to go to tiebreakers to decide who would be making the finals. So we're very confident we have some absolutely excellent opening statements for y'all to hear tonight. But without further ado, we'll go ahead and kick it off with our first finalist in this category, Shannon Klimiko. For those of us who are just joining, Shannon, could you go ahead and introduce yourself again?
Hi. Yeah. Good evening. Shannon Klimiko. I'm from Montgomery Bell Academy in Nashville, Tennessee.
Thank you so much. So you'll have 5 minutes to give your opening statement. I'll put time markers in the chat, but you can go ahead and feel free to begin whenever you're ready.
Perfect. May it please the court. Members of the jury. Sometimes the simplest answer is the right one. It's the 4th of July, 2022, here in the state of Roma. And United States senatorial candidate Carla Guibo is hosting a political rally at Olympic Park. At a Secret Service secured entry checkpoint, a man from out of state is stopped in his car. The Secret Service asks him a screening question. Why are you attending the rally? But this man doesn't respond. Doesn't even look at the Secret Service agent. For the next 5 seconds, puts his hands on his wheel, stares straight ahead, before finally answering, I'm here for the rally, which of course doesn't answer the agent's question. The agent asks him to step out of the car. He refuses. The agent orders him out and searches the vehicle. That search uncovered this AR-15 assault rifle with 2 full clips of ammunition. They also find a janitor's uniform with someone else's name on it and a wheelable trash can large enough to hide the AR-15. The man attempting to enter the political rally with an assault rifle in disguise was a defendant, Tracy Hancock. Mr. Hancock is charged with the attempted murder of Carla Guibo. In this trial, we must prove the 3 elements of this crime beyond a reasonable doubt. First, that the defendant did something that was a substantial step toward killing Carla Guibo, and that strongly corroborated the defendant's intent to commit that crime. Second, when the defendant took that substantial step, the defendant intended to kill Carla Guibo. And third, that the attempted killing occurred within the United States. But as you listen to the proof, I'd like you to keep 3 questions in mind. First, why would the defendant attend a political rally for an election in which he can't vote? You see, the proof will show the defendant lived in Atlanta, Georgia, not within the state of Roma. So he wasn't eligible to vote in Roma's Senate election. That means the defendant wouldn't be voting for or against Ms. Guibo. Second question, why would the defendant lie about attending the rally? You'll learn that the night before the Guibo rally, the defendant stayed at the Henrico Hotel. When he checked in, the proprietor of that hotel, a man named Maury Walensky, asked the defendant what brought him to Roma. And the defendant replied, oddly, nothing. When Mr. Walensky asked the defendant if he was going to the Carla Guibo rally, the defendant said he wasn't. You'll learn that when Mr. Walensky cleaned the defendant's room the very next day, he found a map of Olympic Park, where the rally was happening. Finally, the third question. Why would the defendant bring an assault rifle and a disguise to a political rally? You'll learn that the janitor's uniform had the name D. Lyle on it. When the Secret Service agent asked the defendant at the security checkpoint who D. Lyle was, the defendant wouldn't answer. but the evidence will show the defendant has no connections with any janitorial service or anyone who works at a janitorial service. Members of the jury, my grandpa always said, if it looks like a duck, walks like a duck, and quacks like a duck, you've probably got yourself a duck. So at the end of this trial, when you consider why the defendant traveled out of state for a campaign rally, why the defendant lied about it, and why the defendant brought an assault rifle into disguise, when you consider those questions alongside all the evidence you'll hear, I am confident the government will have met its burden. At the end of this trial, I'm going to ask that you find the defendant guilty of attempted murder. Because sometimes the simplest answer is the right one. Thank you.
Excellent job. Oh, looks like you were right in the nick of time. Excellent job. We'll go ahead and turn it over to our judges for feedback. We'll go ahead and start with Will and then move to Justin.
Yeah, really, really excellent job. I think in terms of some positive feedback there, I think one of the things I pay attention to most in opening statements is that really attention grabbing first paragraph that also explains to me what we're going to hear about. Those two things kind of in concert are really difficult to do, and I thought you did it really well. You both kind of introduced me to the parties and what we're dealing with and the gravity of the situation, but also did it in a really dramatic, eye-catching way. So I thought that was really well done.
Yeah, I agree with everything Will said. I have the unenviable job of giving the constructive feedback for opening statements. Shannon, you were great. A few suggestions. I think you can use simpler language at times. You're very articulate, but remember you're connecting with usually a lay audience and things like proprietor, right? And so use simpler language when you can. I think on a more substantive scale, when you did the 3 points for your elements and the 3 points that you're going to prove or the 3 questions, I had trouble understanding the connection between them. I didn't know which of those questions went to which of those elements. I mean, for example, the third element was this happened in America. I don't know that you need to make that part of your opening. And I think you want to sort of zero in what those questions are going to. I guess the last point is more tonal. Everybody's going to have different views on how opening should sound when it comes to being argumentative. I think that asking rhetorical questions, particularly in a government opening when you're the one supposed to be answering the questions, probably wouldn't do that. And I thought the analogy was good, but I think it's more appropriate for closing. I sound critical because that's my job tonight, but I echo everything Will said. You're terrific.
Thank you so much.
Nice job.
All right. Good night, y'all. Thanks. Appreciate it.
Night. And congrats on being in both categories. That's tremendous.
Yeah. Congratulations.
All right. Our next finalist in this category is Ian Gardner. We'll just give him a moment. Hello, Ian. Congratulations on making the finals. Before we get started, why don't you go ahead and tell us where you're from?
Is my microphone on?
Yep, you're all good.
All right. So I'm from Central Carolina Homeschoolers. I live in McLeansville. It's close to Greensboro, if you're familiar with the area.
Awesome. Glad to hear it. So as you know, this is our opening statement medal round. We'll be timing you. You have 5 minutes for your opening statement. I'll go ahead and put notifications in the chat to keep track of your time. And you can go ahead and start whenever you're ready.
All right. The defendant wants you to live in fear. It was July 4th, 2021. In Roma City, it was sunny with a cool breeze in the air. There's a crowd gathering. They're there to see Carla Gibo, candidate for Senate. And as they gather, they think that they're going to be safe. But there's someone else, someone who wants them to live in fear His name, Tracy Hancock. In the back of his car, an assault rifle. His mission, to kill Carla Gibo. To make you live in fear. Good evening. My name is Ian Girdner, representing the prosecution in today's case. Today, we're charging Tracy Hancock with attempted murder. We have to prove three things today. First, that the defendant took a substantial step towards killing Carla Gibo, and that when he took that substantial step, it strongly corroborated his intent to commit that crime. That means we have to show that the defendant took some type of action that strongly suggests that he was going to go through with killing Carla Gibo. Second, we have to prove that when he took that substantial step, it was his intent to kill Carla Gibo. Finally, this one isn't even in dispute, that the crime would have occurred in the United States. We have to prove these things to you beyond a reasonable doubt. A burden that we, the prosecution, welcome. And we'll prove it to you using three things: what was in the defendant's room, what was in the defendant's car, and what was in the defendant's gun. You're going to hear from Mari Walensky today. They were the clerk at the Henrico Hotel in Roma. They've checked the defendant in on July 3rd, and they explicitly asked them if they were going to Gibo's rally. The defendant said, no. That was a lie. That was the same rally the defendant would be arrested at. Why was he lying? Just look at what was in the defendant's room. Mari Walensky will tell you that when she cleaned the defendant's hotel room, she found a map of Olympic Park, the same place Carla Gibo was going to have her rally. The defendant knew what he was doing. You're also going to hear from Secret Service agent Patty Lester. They were doing security for Gibo's event and asked to search the defendant's vehicle. The defendant said, I'd rather not. He was trying to hide something. Agent Patty Lester will show you what was in the defendant's car. An AR-15 style assault rifle. But most importantly, Agent Lester will tell you what was inside the defendant's gun. A fully loaded magazine of ammunition. He was there to kill. Here in the United States, we're a country that values freedom. On July 4th, 2021, the people of Roma were exercising their freedom of speech, their freedom of assembly, the freedom to choose their own leaders. But there are some that don't want us to have those freedoms, that would rather have us live in fear. Tracy Hancock was trying to send a message on July 4th. He was trying to say that if the people of Roma exercise their freedoms, they would be met with lethal force. Members of the jury, you need to send a message today that any attempt to use violence and intimidation to suppress our civil liberties, any attempts to try to make us live in fear of exercising our rights, will be met with the fullest extent of the law. The defendant wants you to live in fear. Don't let him win. Find the defendant guilty. Thank you.
Excellent job. Thank you so much, Ian. Just like last time, I'll go ahead and turn it over to Will and Justin to give you some feedback.
Yeah, congratulations, Ian.
Thank you, Justin.
There we go. There we go. Congratulations, Ian. That was really well done. I thought I particularly like the organization, the structure. You give me like a tagline for each of the pieces of the evidence, the facts that you really wanted me to pay attention to throughout the case. Those are things that would stick with me, and I'd really be able to remember. And then, of course, be tied together again in closing. So those are really good tidbits you want to put out there for a jury, especially in an opening statement. Things to help them latch onto, particularly with witnesses, so they know what to listen for. So well done.
Yeah, you're terrific. I loved how slow you were. Two suggestions for you, Ian. One on the performance side and one on the substantive side. On the performance side, you do a great job of being slow, methodical. You're intense. When you were explaining how the defendant should be scary, you heightened that. That was great. When you wanted us to be afraid at the beginning, really effective. But I think you want to vary that. It's a 5-minute speech. And so you want moments that show variety, right? A softness, a tenderness, a curiosity, whatever you want us to be feeling, but you don't want us to be feeling the same emotion for 5 minutes. On the substantive side, I thought that there were times when you crossed the line on what we call the golden rule, that is referencing the jury and asking the jury to be in certain people's shoes. And I thought that at the beginning, when you said he was trying to scare people there, okay. But then when you said he was trying to scare us, the jury, I think that's probably over the line. And then you had a line at the end where you said the same thing, where you referenced how the jury should feel. And I think at that point, you're risking an objection from opposing counsel in a real trial to where it becomes inappropriate argument. But tremendous job. I can totally see how you qualified for the medal rounds. Really great job. And you come from a very successful school. No shock to see Central Carolina was represented here. So congratulations.
Thank you.
Truly. Congratulations, Ian. And good luck in the competition. Thank you for your performance.
Congratulations. Thank you again for joining us, Ian. And with that, we'll go ahead and take it to our next finalist. We'll give her a moment. Lady Gonzalez. All right. So it looks like she's here. Our next finalist is Lady Gonzalez. If you could go ahead and turn your camera on. Hello.
Hi, good evening.
Good evening. Why don't you go ahead and tell us where you're from?
Well, I'm born and raised here from Hialeah, Florida. I've basically lived here my entire life. This is a super Latin community, so my parents are Cuban. They came here from Cuba. And yeah, we're really happy to be here.
We are happy to have you here. So just like the last time, you know how it goes. You have 5 minutes to give your opening statement. I will go ahead and time you, and I'll put notifications in the chat minute by minute and closer, a little bit smaller when you get closer to your time. And then we'll turn it over to our judges for some feedback. But whenever you're ready, you can go ahead and begin.
Is it all right if I start now?
Yes, go ahead.
Okay. He was a man with a plan who only had one mission. Ladies and gentlemen of the jury, what you see before you is a picture of an AR-15 assault rifle. It can fire up to 150 rounds in just 15 seconds. It can obliterate its target instantly. And it only has one purpose: to end lives. On the early morning of July 4th, 2022, this AR-15 assault rifle was found in the possession of the defendant Tracy Hancock when he was stopped by authorities in a political rally in Roma City at Olympic Park. Scheduled to speak at this rally was gubernatorial candidate Carla Gibo, an outspoken politician who was clashed with many on both sides of the political spectrum. The evidence will show that it was no coincidence that the defendant was at the Gibo rally, nor was it by chance that he had a wheelable trash cart and a janitorial jumpsuit in his possession. And it was definitely not by chance that he carried an AR-15 assault rifle with 2 full clips of ammunition in his vehicle, because he was a man with a plan who only had one mission: to murder Carla Gibo. Your Honor, opposing counsels, ladies and gentlemen of the jury, may it please the court. My name is Lady Gonzalez, and I represent the U.S. government in the case of U.S. versus Tracy Hancock. The government intends to prove that the defendant is guilty of the attempted murder of Carla Gibo. Now, according to Section 1113 of Title 18 of the United States Code, it states that in order to convict a person of attempted murder, the state must prove three things. 1. That the defendant did something that was a substantial step toward the intended killing of the victim, and that strongly corroborated to the defendant's intent to commit that crime. 2. When the defendant did that substantial step, the defendant intended on killing his would-be victim. And 3. The attempted killing occurred within the United States. Now, the defense would have you believe that the defendant happened to show up to the Gibo rally with a semi-automatic rifle in his car by chance. But what this case is really about is a man with a plan to assassinate a political candidate, but was stopped by political authorities before he could proceed, and stopped. To support our case theory, we, the government, will present two witnesses who will testify to this honorable court. First, you will hear from Mari Lewinsky, the innkeeper at Henrico Hotel. She will not only testify that Hancock lied to him about not wanting to attend the Gibo rally, but she will also testify that when she searched the defendant's room, she found a map of Olympic Park in his hotel room, a map of where Carla Gibo was to give her speech. Lastly, you will hear from Patty Lester, the Secret Service agent who stopped the defendant. She will not only testify that the defendant was evasive when questioned, but she will also testify that when she searched his vehicle, she found an AR-15 assault rifle, 2 full clips of ammunition, a wheelable trash cart, and a janitorial jumpsuit with the name D. Lyle sewn into the front. The evidence will show that all these items were to be used in the defendant's plan to shoot and kill Carla Gibo, and then slip away into the crowd, disguised as a janitor. Now, the government is fully aware that we have the burden of proving beyond a reasonable doubt that the defendant is guilty of the attempted murder of Carla Gibo. But let's take a moment to understand exactly what that means. Beyond a reasonable doubt doesn't mean that there aren't any doubts, but rather than a jury should not convict a defendant of a crime unless there's at least a very high probability that they committed that crime. The government is confident that we will reach this threshold and that we will provide all the evidence to support its burden of proof. And once you see the facts and weigh the evidence, it will become very evident that there's only one logical conclusion: that the defendant Tracy Hancock is guilty of the attempted murder of Carla Gibo. Thank you, Your Honor.
Thank you. Great job. I'll go ahead and turn it over to Will and Justin for some feedback.
Yeah, really, really well done. I thought just for me, it was just the passion in the speech and the conviction with which you went through everything and the organization, the structure that you had to it. And you kind of brought it all home at the end by just throwing in the law, telling me why it mattered and why you win. And I really thought that was well done and very persuasive. So well done.
Lady, you're terrific. I really liked your hand gestures. You use them very effectively. And so my suggestion is when you're not using them for gestures, have them at your sides rather than clasped in front of you. It makes you look stronger when you're at your sides naturally, just relaxed, than if you clasp them, right? It makes you look closed off or a little nervous. And you have no reason to be nervous. You're terrific. On the substantive side, I think there were elements of law you went into more depth than you would in a real life opening statement. For example, the jury doesn't need to know the section code of the United States Code. They don't need to know the number. Similarly, I don't think most judges would let you open on the definition of beyond a reasonable doubt. I think as the government, you need to acknowledge it, and you definitely score points for saying, hey, we've got the burden, we're going to meet it. But you went into more depth there than is probably appropriate in opening statement. You want to just tell the jury what you're going to prove. You don't need to define the legal standard, just let them know what it is. But those are nitpicks. You're terrific. Great job.
Thank you, lady. Next up is Lindsay Maxfield. We'll give her a moment to join us.
Thank you guys. Have a good night.
You too. Thanks for joining us. Hello, Lindsay.
Hi.
Thank you for joining us tonight. Congratulations on making the finals. Before we kick it off, why don't you go ahead and tell everyone where you're from?
Hi, I'm Lindsay Maxfield, and I'm from Apple Valley High School, which is in Apple Valley, Minnesota.
All right. Now, just like our other finalists, you'll have 5 minutes to give your opening statement. I'll give you time warnings on the chat, so keep an eye out for those, and then we'll turn it over to our judges for some feedback. But you can go ahead and begin whenever you're ready.
Being aloof is not sufficient proof. That's really what this case is all about. The government found someone who avoided a few questions and stopped. Called it a day. They didn't consider all of the evidence. They didn't consider other possibilities. And because the government jumped to conclusions, they have charged an innocent man. The government has charged Tracy Hancock with the attempted murder of Carla Gibo. In order for a defendant to be found guilty of that charge, the government must prove the defendant, 1, did something that was a substantial step toward killing Carla Gibo, and 2, prove that the defendant intended to commit that crime. But the government will fail to meet their burden. Let's start at the beginning. On July 4th, 2022, politician Carla Gibo was having a rally right here in Roma. As you probably remember, Ms. Gibo was running for our open Senate seat and had a rally scheduled in Olympic Park. The evidence will show that Tracy Hancock is a big fan of Carla Gibo's politics. And while he may not agree with everything Carla Gibo has to say, Tracy was excited to get an opportunity to see her talk in person. So, on July 2nd, Tracy Hancock left from his home in Atlanta, Georgia, and took the 10-hour trip to Roma. He checked into the Henrico Hotel the following day. You'll hear from the receptionist at the hotel, Mr. Maury Walensky. Mr. Walensky will testify that he saw Mr. Hancock check in on July 3rd. He will tell us that Tracy Hancock was in normal clothes and had nothing on their person. Nothing really suspicious at all. In fact, the only thing out of the ordinary that Mr. Walensky noticed was that the defendant was avoiding their questions, that they were acting aloof. But members of the jury, remember, being aloof is not sufficient proof. And the next morning, the evidence showed the defendant drove to the rally Olympic Park, where he entered a security checkpoint manned by Secret Service agent Patty Lester. Agent Lester will testify that they asked the defendant several questions. And again, the defendant was avoiding their questions. But members of the jury, remember, acting aloof is not sufficient proof. Agent Lester will go on to say that when they searched the defendant's car, they found this gun, an AR-15. When Agent Lester asked the defendant about the weapon, he was honest. He admitted that the gun belonged to him and that he had a valid permit. The evidence will show that this information was true. You'll see today that the firearm was properly registered to Tracy Hancock in Georgia, just like he said it was. At this point, I'd like to take the opportunity to remind you that today it is the government that has to prove something to you. We don't have to prove anything. It is the government that has to prove that Tracy Hancock intended to commit murder. And let's be clear, they can't just show it's possible that Tracy Hancock intended to commit this crime. It's not enough to say that some evidence might point to Tracy Hancock. No. They have to prove Tracy Hancock's guilt beyond a reasonable doubt. But as you listen to the witnesses today and hear the evidence, you will have reason after reason to believe that the evidence pointing to Tracy Hancock is flawed. And reason after reason to believe that there are legitimate reasons for the items Tracy Hancock had with him on the day in question. And reason after reason to believe that being aloof is not sufficient proof. And that's why at the end of this trial, my co-counsel, Ms. Emily Bauer, will come before you and ask for a verdict of not guilty. Thank you.
Excellent job, Lindsay. Thank you so much for joining us. I'll go ahead and turn it over to Will and Justin for some feedback.
Sure. Well done, Lindsay. I thought that was really well structured. I think my biggest feedback for you was the movement. I think your instincts for movement and moving to demonstrate changes in topics and points in your opening was really good. And I think that's really something that you'll be able to build on and use kind of going forward, because that is a hard thing to know and to teach. So your instinct there is really strong. Well done.
Thank you.
Lindsay, that was terrific. I'm really impressed. A couple suggestions on the performance side. You did a really smart job of being calm and reasonable, right? Your defense, there's some bad facts, and you know that the prosecution is going to come out fiery. And so you did a good job of changing the temperature. But you need to add some more variety to the performance, because it was steady throughout, but at times you want to keep the jury attention, and you're going to need to change your tone more and add some energy throughout that opening statement. So even if you're going to start on the quiet side, you want to build some energy. We had a couple moments, but there could have been even more. I also think that you could acknowledge some of the bad facts more. I mean, you made it seem like being aloof was the worst fact. I'm not sure that being aloof was the worst fact. I think the worst facts are lying and having a deadly weapon. So I would emphasize what your defense is on those. And finally, this is a tough call because you don't know if your client's going to testify, but your opening sort of promised a little bit of the story. And if your client doesn't testify, you're not necessarily going to be able to introduce that. So that's a risk you're taking there. And maybe it's one you're willing to take, but I'd be careful. Terrific job. I echo everything Will said. Congratulations.
Thank you.
Excellent job, Lindsay. Our next finalist, coming back again for his second round of the night, is Jacob Molina. We will give him just a moment as well. Hello, welcome back, Jacob. All right, so for those of us who are just tuning in, will you go ahead and tell everyone again where you're from?
I'm Jacob Molina, and I'm from Dos Pueblos High School in California.
Awesome. Thank you for joining us again for your second round of the night. For this category, just like everyone else, you'll have 5 minutes to give your opening statement. I will give you time warnings in the Zoom chat, and then we'll turn over to our judges for some feedback. But whenever you're ready, feel free to begin.
Crime only existed in the agent's mind. It's July 4th of 2022, and Mr. Hancock is driving to a political rally. He's coming from Georgia, checked into a hotel the night before, and there's nothing unusual about his vehicle. He stopped at a checkpoint, ordered out of the car, and later arrested. But what happened? What turned this ordinary stop into an arrest? It's because a crime only existed in the agent's mind. Now, the government has charged Mr. Hancock today with attempted murder, and they have the burden of proving that beyond a reasonable doubt. They won't be able to meet that burden. You'll learn that the agent's suspicions of Mr. Hancock were nothing more than a hunch. It was guesswork. The evidence will show that the reason the agent suspected Mr. Hancock to begin with was that he paused before answering a question. The government won't be able to provide evidence to show how Mr. Hancock ordinarily conducts himself in social situations. They won't be able to provide any conclusive evidence as to Mr. Hancock's state of mind. Mr. Hancock was understandably nervous after being stopped by a special agent. He was understandably nervous after being questioned and asked to identify himself. He was understandably afraid of the agents trying to create a crime out of nothing. Now, the government mentioned that you'll learn that Mr. Hancock had a gun in his car. And he did. But you'll learn that this gun wasn't stolen, wasn't unlawfully obtained in any way. The evidence will show that it was properly licensed in Mr. Hancock's home state. He had a legal right to own that gun. Having one's property in their car isn't enough for murder. And he also did have a janitor uniform in the car. But the government won't be able to conclusively link that to the crimes they've alleged in today's case. There'll be no evidence that was stolen, be no evidence that was unlawfully obtained in any way. Once again, this isn't enough for murder. But from the very beginning, the agent was determined to make Mr. Hancock look suspicious. He ignored relevant evidence and failed to investigate the entirety of the situation. But what he did investigate yielded no evidence. You'll learn that the agent searched Mr. Hancock's phone, looking for any evidence, and he found nothing. You'll learn that he spoke to Mr. Hancock's friends, trying to figure out if he had any strong political beliefs, and once again, he found nothing. You'll learn that he verified what Mr. Hancock told him, looked for discrepancies, seen if he had lied, and once again, he found nothing. Mr. Hancock is still being charged with attempted murder. Now, as you watch today's case, remember that Mr. Hancock is presumed innocent. The government has the burden of proving his guilt beyond a reasonable doubt. And as you watch today's case, it's going to be full of doubt. You'll be left with questions, and at the end of today's trial, they won't be able to conclusively tell you what Mr. Hancock was thinking. There'll be no reason to believe that he was thinking of killing someone that day. That's because a crime only existed in the agent's mind. At the end of today's trial, we're going to ask you to find the defendant, Mr. Hancock, not guilty. Thank you.
Excellent job, Jacob, and congrats on making it this far. I'll go ahead and turn it over to Will and Justin for some comments.
Yeah, really, really well done, Jacob. I think for me, what stuck out for me from your performance was just the kind of the timing and pace of your speech was so intentional. And you used pauses to your benefit. You had a really good intensity about pretty much everything you were doing, but it wasn't too much. I thought it was really well done in terms of its pauses and the flow that you had going, and it kind of just captured my attention, and you had it the whole time. So excellent job.
Thank you.
Yeah, I thought your presentation was great. I really liked your theme and the thrust of your argument. I think the thing that stood out to me most was there are times when you were argumentative, and I'll give you an example that stood out to me. When you said he's understandably nervous, he's understandably concerned. And I guess I have two issues there. One is, I think at that point you're arguing in its opening statement, you're telling us your opinion that it's understandable, but also it's actually even more effective and persuasive to not say understandably, instead to let us draw that conclusion. I mean, he's behind the wheel of his car, he's excited to go to this rally, and all of a sudden an armed federal agent orders him out of the car. Like, let us feel that fear instead of telling us that he must have fear. Let us think that it's understandable without you telling us. I think you'll get a better reaction from your judges and your jurors in real life if you let us draw that conclusion ourselves. But terrific performance, really great job. And as you said to Mr. Klimenko, congratulations on qualifying for the finals in both events. Very impressive.
Thank you.
Congratulations, Jacob. And With that, we'll head it off for our last finalist of the night, Jack Spillner. And we'll give him a moment too. Hello, Jack.
Good evening.
Good evening. Thank you so much for joining us tonight. Before we get started, why don't you go ahead and tell everyone where you're from?
I'm from Hillsdale High School in San Mateo, California.
Great. Thanks so much for joining us tonight. Just like everyone else, you'll have 5 minutes to give us your opening statement. I will give you time signals in the Zoom chat, so keep an eye out for that. And then we'll turn it over to our judges for some comments, but you can go ahead and get started whenever you're ready.
Patty Lester wanted to play the hero, but heroes need villains. Agent Patty Lester is a member of the Secret Service, the highest protective service in the nation. Her entire career, she's protected dozens of important people. Supreme Court justices, senators, even a president. Her entire career, she's been the hero. That's her job. The sun is rising as the defendant, Tracy Hancock, arrives at a rally for a controversial candidate. He approaches a checkpoint where he's stopped by Agent Lester. She questions him and makes him step out of the car. Then she looks in the trunk and she sees a gun. At this moment, Tracy Hancock's fate is sealed. The evidence will show that even though they found nothing suspicious on his body, nothing suspicious in his hotel, nothing suspicious on his phone, Tracy Hancock was still arrested. Because Patty Lester wanted to play the hero. And heroes need villains. This is Tracy Hancock. He's 27 years old, works at a sporting goods store in Atlanta. His life is just beginning. And like everyone else there that day, he was just there for the rally. But today, the government, they've charged Mr. Hancock with the attempted murder of political candidate Carla Gable. They had the burden of proof to show beyond a reasonable doubt two things. One, that Tracy Hancock intended to kill Carla Gable. And two, that he took a substantial step to do so. But members of the jury, the government, they won't be able to meet their burden today because they won't be able to prove either element of their charge. They won't be able to prove intent, and a substantial step was never taken. First, intent. You'll hear that Agent Lester searched Tracy Hancock's phone. She checked apps, search history, texts, emails, and what did she find? Nothing incriminating. In fact, the evidence will show she found nothing suspicious at all. You'll also hear Tracy Hancock's hotel room was searched. They found nothing more than a t-shirt, some socks, and a toothbrush. Agent Lester interviewed Tracy Hancock's coworkers. And not once had he mentioned politics, and not once had he mentioned Carla Gable. Second, a substantial step was never taken. You will hear that Agent Lester found a gun, a legal gun that was licensed to Tracy Hancock. Now, the government, they're going to get up here and tell you that this was a substantial step. But members of the jury, the evidence will show the bullets were never shot. The trigger was never pulled. The gun was never fired. You'll hear that it stayed in Tracy Hancock's trunk the entire time. Patty Lester wanted to play the hero, but Tracy Hancock is no villain. At the end of today's trial, we'll ask you for a verdict of not guilty. Thank you.
Excellent job, Jack. What a great way to finish off our last medal round of the night. I'll go ahead and turn it over to Will and Justin for some comments.
Yeah, really, really well done there, Jack. I said it to our first competitor there for the opening statement, and I think really it came through in yours as well, especially putting in the context of a trial after hearing probably just a government opening statement, right? Your first statement, your first paragraph right out of the gate was just flipping the case on its head, right back at the government, right back at their agent. I thought it was really well done, and reframing this trial in the way that you want the jury to be thinking at it right from the start. I thought that was really strong.
Thank you.
Yeah, Jack, great job. I thought we were going to be judging best opening, but seeing you and Jacob back to back, I felt like we were judging best hair. So I'll leave that to the other judges to decide. But you're great. I'll give you two suggestions. One, I love the fiery delivery in the defense opening. I think you can have more variety though. Related to that, I think you can have more humility on the defense. I don't mean that you personally need to be humble, but I think you need to acknowledge some bad facts. It's good to spin some of them, and you did that, but there need to be some somber moments because they've just heard probably a roaring statement from the government about these bad facts, and I think that you can sort of deal with them a little bit. And I think that there are times during that opening when you can humanize your client even more, but I liked having your client turn on the camera. That was effective. I guess my last suggestion is, I think it's wise to attack the government theory. I think it's dangerous to go after the agent. I don't know that you have the actual factual ammunition to suggest this person's corrupt or a bad actor or just looking to move up. I don't know that you have that on cross. And so I think you can defend your client without risking going after the cop. I mean, in mock trial, as in real life, it can be very effective to attack law enforcement in your own defense, but I'm not sure you have the facts for that here. And so I really love when you got into the meat of the argument, you talked about not loaded, not even out of the trunk. I like that argument more than the attack on this particular agent. But again, tremendous opening statement, great job, and a wonderful way to finish the night.
Thank you. Thank you guys so much.
Congratulations again, Jack. And to everyone watching, thank you so much for joining us. We really appreciated having you here for day one of the medal rounds. It was a pleasure to host this competition, and we really enjoyed watching all of your submissions. And congrats one more time to all of our finalists who made it this far. To wrap us up tonight, I will turn it over to Justin for some final words.
Yeah, thank you to Rhea, to Bennett, and to Will for their great judging tonight. Thank you to our 12 performances from 10 different competitors from across the country. Can't wait to see the next 12 tomorrow and to announce the winners on Wednesday. Thank you for enjoying and participating in our first night of the Gladiator Olympics. See you tomorrow.